This is the state of Texas versus Elizabeth Yepes. And trust me, this case is going to test the balance between second chances and harsh consequences. Elizabeth Yepes is facing sentencing after entering a plea of no contest to a serious drug charge. On paper, this looks like a straightforward plea bargain: 6 years in prison, a hefty fine, and no probation. But here's the twist. The defense is about to argue that despite her record, she deserves one last shot at freedom. And the judge? Well, he's not convinced so easily. Stay with me, because what unfolds is a gripping back and forth about redemption, accountability, and whether a criminal past can ever truly be left behind. Who do you think should prevail? The state seeking prison or the defense fighting for probation?
Court is calling 2021 CR 9284, State of Texas versus Elizabeth Yepes. We have parties announced for the record for the state.
Marcus Sanders.
For the defense.
Robert Mao for defendant.
Are you Ms. Yepes? All right, you entered a plea on May 9th to count 2. You entered a plea of no contest. The state waived the enhancement and count 1 without objection. According to the plea bargain agreement, punishment is to be assessed at 6 years in the prison. There's a $1,500 fine, and the state opposes your application. Have both parties had a chance to review the PSI report, state?
Judge, not yet, but I'm working on it.
Judge, I've reviewed the PSI. It's pretty straightforward. The state was opposed based upon, I think, the prior criminal history and the amount of drugs.
All right. So are both parties ready to proceed, state?
I'm ready.
Defense? All right, state, you are opposed.
Yes, Judge, we are.
Do you have any witnesses?
No, Judge.
All right, defense, do you have any witnesses?
Judge, no, I'm just arguing on behalf of my client.
All right, the court will hear argument, state.
Judge, that's correct what defense counsel said. Our opposition is based mainly on this defendant's criminal history. Looking at the PSI, it looks like she's been given a chance at probation at least twice before. It looks like in 2005, she was granted probation for 10 years on a felon in possession. And she ended up being revoked. And actually in 1993, she was given deferred and then placed on probation and got revoked. So that's twice that she's been given a chance. It looks like we played the offense down just to give her a little bit of benefit for accepting responsibility for her actions. But that's why we don't believe probation would be appropriate in this case. We're asking for prison sentence.
All right, defense.
Judge, we understand fully why the state made the recommendation they did. Ms. Yepes asked me to speak on her behalf because I think she's kind of nervous speaking in public. Since her release on this case, Ms. Yepes, I think, has made significant strides in turning her life around. She finally got a job at Mood Solutions. She's been made a supervisor. She makes $15 an hour. I think this is probably the best job and the best situation she's found herself in. I guess for a number of years. I think she's really got her situation solidified, and I think she would benefit from the opportunity for probation with whatever terms of what was appropriate. That's obviously the most important thing. I would like the court to consider that and consider one, I think, remorse for finding herself in the same situation again. I think TAP talks about issues that have been on again, off again with drugs in her life. You would ask the court, if the court does see fit to give her probation, to allow her to do intensive outpatient. She's very concerned about keeping this job that she was finally able to get. I think it's very difficult for people with Elizabeth's criminal history to find jobs in the workforce. And I think this company is willing to work with her. And I think it's put her in a situation where she can be a successful part of society. So that's the court to grant that.
All right, so the court has a question.
That right there is one of the most striking moments so far. The judge compares Elizabeth's criminal record to a credit report, except instead of finances, it's about trust and responsibility. Think about it. Every conviction is like missing a payment. every probation revocation is like defaulting on a loan. And when your report looks like hers, it signals risk. Judges use this metaphor because it's relatable and hits hard. It's the perfect way to explain why probation is a privilege, not a right. And in Elizabeth's case, her credit score in the justice system is badly damaged.
Because it says on here, guilt minimized.
I think they were talking about on her, when I look at that, when I read that, I think they were on the type evaluation, they were talking about her drug usage.
Okay. All right, Ms. Yepes, can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. Did you commit this offense? All right, so I want to talk to you about your criminal history because that is concerning. I always tell people the criminal history is sort of like a credit report, but it's a credit report related to whether or not I should give you probation. You understand? So your misdemeanor cases, this theft, you were sentenced to 32 days in jail. And I understand how that happens. People just want to get their judgment satisfied and be done. The same thing with hindering apprehension. Then we have the assault, bodily injury, family, household, 90 days, theft, 44 days, possession case, 20 days, another possession case, 20 days, then failure to ID, 1 year. So this is what's concerning to me. You pick up a felony in 1992 and you were granted deferred adjudication and you didn't complete it. Why didn't you complete it?
It's very young. My husband was very abusive and I didn't do what I was supposed to do. I didn't go to classes.
All right. November 2005, felon in possession of a firearm.
That was at my house when they came looking for my son. My house, it's my husband's house at the time. I was charged with that.
All right. Then we have December, the drugs, 4 to 200 grams.
But he was a,
You don't remember,
I
just
don't
tell you.
remember,
All right. So then we have 2007. You were sentenced to prison and then you had a parole violation. It appears that you're not learning anything from your prison. Then we have 2014. So 2014, prison, paroled, felon in possession. I'm assuming these cases were ran concurrently. And now we're here. So I don't understand. I don't know if there's anything that I can do for you because you have not learned anything.
this last time I've learned a lot. I haven't worked in my life like that. I've worked now. I've been working for almost 3 years now. I was given a chance to get a position as a supervisor's responsibilities that I have to do. Something I haven't done in many years. So it's just I feel like I've worked for it and I want to continue to keep it. If I lose it all, then I feel like that's my age and that with my history, my background, which is not ever going to change. I won't be able to. I won't make the lifetime.
This is the classic clash between compassion and accountability. The judge openly admits he's sympathetic to Elizabeth finally getting her life in order, but then he hits her with the harsh truth: your history is awful. That's the judicial dilemma in a nutshell. Sympathy might make you want to grant probation, but precedent, risk, and the sheer weight of prior convictions pull the other way. Notice how the judge even says, "I don't know if there's anything I can do for you." That line isn't just courtroom talk. It's the moment Elizabeth's fate shifts from possibility to inevitability.
And I'm sympathetic to what you're telling me. I'm sympathetic to you getting your life in order, maybe finally. But here's the problem. The amount of drugs was a lot. And your history is awful. All right. This is what I'm going to do. I'm going to find her guilty, as previously stated. I'm going to sentence you to 4 years in the prison. Give you credit for any time served. There's a $1,500 fine. Time and money will run concurrent. All All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. Do you understand? All right, and we're off the record. Ms. Yepes, I actually gave you less than what you bargained for, because I did consider the fact that you did come in with employment. You understand? Do not come out and do this again, because you don't know who your attorney is going to be. You don't know who the prosecutor is going to be or who the judge is going to be. And you will be a habitual, and your minimum will be 25 years in prison. You understand? All right. Good luck to you.
Thank you, Judge.
You're welcome. Jose Munoz.
That's my case, Judge. It's a first setting. I was just going to ask the court if we can get another reset for discovery.
So let's break this down. Elizabeth Yepes entered a no contest plea, faced a possible 6 years, and ultimately walked away with 4. The state hammered her past, multiple probation revocations, serious drug offenses, and a history the judge himself called awful. The defense countered with her progress, a steady job, supervisor role, and a plea for one more chance. In the end, the judge split the difference. Prison time, but less than bargained for, with a very clear warning for the future. This case is a powerful reminder that in the courtroom, your history never truly disappears, but your present progress can still make an impact. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.